Good evening and a very warm welcome. Today we have with us Professor Dr. Upendra Baxi, a renowned legal academician. So my first question to you is, the Honorable Supreme Court has referred to the Constitution Bench to consider the constitutionality of establishing a National Court of Appeal, which will act as the final court for civil and criminal matter. What are your views on the present issue?
Well, technically the matter is sub judice. The Lordship will ultimately decide. But I can tell you that it's a very welcome move which is here of this matter, because in the past there have been several proposals. One of the proposals was a national court, another proposal was setting up a constitutional law bench and other benches, appeal bench and things like that. And there were several related proposals, but they did not work. There was no discussion. So I'm very glad that the court at last is there's a proposal that this Supreme Court should circuit or there should be benches like the federal court, its predecessors have in some southern states and so on. But all these suggestions were considered and they were put aside. So I'm very glad that the matter has come to judicial decision. Second, the court has consistently widened what we call access rights. That is to say, access to justice is a very important value. And as late as 2013, I think, there's a case involving Haryana. It became the case, but the Justice Agarwal gave a judgment. Chief Justice was then, I think, and some other justices. And there's a very important paragraph there, where the court says there is not merely a right to access in general, but there is a right to access to judicial infrastructure. This is a case involving Speedy Trials Act, and whether the court can sit on Saturday or Sunday, and whether they would have good furniture or something. That was infrastructure matter. That was not about benches, but there should be circuiting, there should be benches, or there should be new court. But the remark is extremely important. The observation there, one paragraph full of observation by the court, saying that people have a right to judicial infrastructure. I don't know what is argued, how it is argued. A good lawyer would refer to the 2013 decision, which I think has broadened the sphere of access and reduced the sphere of territorial authority. Because if you consider that the court, Supreme Court, belongs to the organ of the state, then it becomes a matter of governance and management of politics. But if you say Supreme Court of India has become, as I say, a court for India at last. Everybody goes to Supreme Court. And what I call social representation. For making new policies, new rights, the court obliges in certain cases, goes without another. So that if this transition has occurred from this governance institution merely to a people institution, then access values there. Very important. Access to justice is a very important democratic value. So the hearing of the case in itself, whatever be the outcome, is a very good beginning on which we can build.
Thank you so much, sir. So my next question to you is, as an academician who has been instrumental in development of legal education in India, what is your view on the present status of legal education in light of national law universities? And how can we make national law universities more dynamic and socially relevant education institutions?
There are questions upon questions upon questions. Multi-layered questions. I do not, I'm just a law teacher, and I've always loved to be a law teacher. I'm not an educationist. I was called educationist when I held the office of the Vice Chancellor of the university. I said, India is a unique country where you, not merely culture, it's so that you sit on a chair, the ex officio you can get virtue, knowledge, your power, of course, the statute. Ex officio, it all comes by virtue of office. So suddenly, from a teacher, you become an educationist. Education, you have to know philosophy, education, technology, education. And we get the chemistry vice chancellor, working on as a chemist in the lab, he becomes vice chancellor. How does you become educated? All vice chancellors are referred to educated. All lawyers are referred to jurists. It's a country, a fantastic country. So, educationist I am not, teacher I am. As a teacher, I am concerned with education, generally, policies and so on. I think there is a lot of change since the time I began teaching in the law school. Now, there is a lot of change. There now, earlier there were only central, one law school in Delhi was the only school. It was in Parkpur. Now, there is National Law School, there are private universities, there are many more universities which is state run. So, there's a sea change in situation. And UGC is trying to cope by laying down some guidelines, but the guidelines are not reach everywhere. And they are not always right, like doing conversion of Master of Laws into 1 year. I don't believe it's a wise move at all, even though my colleagues might have supported the idea, and the law panel. So this scene has changed very vastly. And I'm glad that national law schools exist, insofar as they are able to set high standards. I don't know whether they do or not, but some do and some don't. I once described the national law school as the mushroom cloud over the traditional law school. Mushroom cloud is the reference to Hiroshima and Nagasaki, the power of nuclear weapons. So, as you know, I am founder of the Bangalore National Law School, I director designate for 13 long years. I planned the curriculum, I planned the test, which are now being utilized. I didn't take up the assignment because the idea of a university either funded by the state or by commercial houses was not my idea of national law school. The idea was that the bar itself create chairs. Each state will contribute $1.5 crore or more as endowment for chairs. And the bar will then thereafter leave the business to the national law school, grant its autonomy. Whether it happened or not, I do not now know. And so, in a sense, national law schools are in some position of advantage, but national law schools have two things to do, in my opinion, which nobody asked for, but I get it. One is that they should integrate what is called pre-law teaching with the law teaching, and they don't do it. So if you are a sociology teacher, you only teach sociology, you never teach torts or contract or labor or anything. And if you are a law teacher, you never teach political science or economics. That's entirely wrong. My idea, my imagination of national law school was that of integration of many disciplines. Because there is no other department in the university except in law. So traditionally it's a misnomer to call a national law school a university. But it is functional to call them a university because they have power to give the degrees, they have autonomy and all that. So I agree with that. But provided there is integration. Because no single department in the university, the world has not witnessed it. Anyway, the idea is a cohesion of social science and more. So that is one thing that national law schools are hopefully doing in future. Second is that their faculty varies very much. I hope they do a faculty, like Gujarat has one good faculty, large faculty. So the teacher-student ratio will be higher than private law school or a traditional settled university. The third thing they will do is to produce not just lawyers for law houses, which is what we do in the name of professional legal education, but what we call in 1990 in the first CDC report, Curriculum Development Commission report, that you don't merely have liberal arts education, but you also prepare, you not only a professional education, you have liberal arts education, liberal education, where people are trained as soldiers of justice, or for justice. They are not just law people. And I hope national laws will do that in future. And then they will be properly called national laws. And they consider equity and justice alongside with law. That is justice according to law and justice beyond the law. Justice that eludes law today. And unless that sense of architecture is cultivated among students, that the present law, whatever it is always imperfect. And you have to transcend it to a better law and still better. And law for social transformation and social equity. Unless that purpose is served, that was the purpose with why national laws were founded. Not only, I'm not saying that catering to the bar is not a necessity. Of course, professional legal education is sound legal education, basic need. But it is not the only basic need. How law is used at the grassroots. How to combat the illegalities of the dominant. That's also a part of legal training, but we don't give it. So, eventually I hope national laws will do that.
Thank you. Thank you so much, sir. It was a great pleasure talking to you.
Pleasure. My pleasure.